Hello, hello, hello. Good evening. Hello, everybody. I have a little different format tonight. Welcome in, welcome in. Hello, happy Friday, everybody. Happy to see. Oh, yeah, yeah. This is a very well, and not unexpected, but a turn nevertheless. Is this on? I can't hear. Oh my gosh. Okay, you can. Oh, good. Yay. Is this thing on? Yeah. Hello, Willie B. Welcome. Heather, Angel, Lisa, good to see you. Yes, so I wasn't planning on doing a live tonight, everyone. So these are actually my Friday night nails. So, whoops. Hello, hello, hello. Yes, it's live, not pre-recorded. Yep, you got it. Hello, Kathy. Hello, Kaya. Good to see you. You've been busy, Kaya. I've noticed that. Keep going at it. Nice work. I love that. Nope, nope, we're not, I wouldn't, yeah, party hands. Sorry, everybody. I wouldn't say this is sad. I would say it's interesting. 11 heads unite. Yes. Rock star, rock out. Yeah. Hello, Lynn. I can hear, just not very loud. Well, hold on a second. I'm at full battery. So there we go. How's that? Maybe that's a little bit better. I had my battery plugged in. Love the Friday night nails. Yes. So I had plans, and I still do have plans, but I'm just moving them to a little bit later time. So, hello, Kristen. Hello. Oh, you can hear me fine. Oh, good. I'm so glad. I'm so glad to hear that. You can hear okay. Okay, excellent. Thank you. Thank you so much. So, I'm working on a new setup here so that I can go onto my computer. This is a 224 pages, everybody. And I just could not print it. I just couldn't do it. So I thought, well, I'll just go ahead and see if I can get us set up over here so we can do it this way for this huge of a document. So, oh, great, great, Jennifer, great, great. Glad to hear it. Yeah, this is quite, it's big, but it doesn't mean that it's good quality. I think we've all learned that, right? Oh my gosh. Yeah, it doesn't just because it's yeah, exactly, exactly, Violet. So the big thing here is that they have added, different chunks of other documents in order to kind of support what they're saying. And, what they're saying really isn't anything new. It's just kind of a condensed format. So, just to remind everybody about what's been going on in this case, again, so this is the Supreme Court case name. If you want this document here, this is the number that was added. So this is the JGG case, and we're talking about the people without due process that were put on the planes and sent to the El Salvador. We don't know how many people there are. We had our district judge, the chief judge in the DC District Court, has put a temporary restraining order on the Alien Enemies Act proclamation because it's not being invoked properly. So it can't be used as a basis for, can't be used as a basis to deport people or to put them on planes and send them to, oh, thank you, Evelyn, and send them to anywhere, really. Can a judge move forward with contempt even if the government claims state secrets? Yes, absolutely, absolutely, the judge can. And this particular judge knows all about the state secrets, affirmative defense, or immunity or privilege that they're asserting. So they're not going to be able to kind of dance around and say, well, we're just going to throw out all of this stuff. This judge is the best judge in the entire US to deal with this kind of stuff because he deals with this stuff like every day. So they can still go forward on a contempt. Absolutely. So we've had that particular judge put in a restraining order, then it was appealed. We had arguments in front of the Court of Appeals for the DC Circuit. I think we listened to that just a couple days ago. And then we had a decision from them. It was 2-3 saying the temporary restraining order needed to stay in place because we needed to have some due process. And now, today, they have filed this appeal to the US Supreme Court. So, this is just the next step in appeals. So, For all of Trump's cases, his administration cases, what you want to watch for, we have the first court putting in those restraining orders and injunctions. Then we get the first appeal, that'll be to a circuit, and then the third appeal, or the second appeal, but the third step will be to the U.S. Supreme Court. So this is the first case. Well, actually, this isn't the first case. I'm sorry, everybody. This is technically the fifth case on lawsuits suing the Trump administration up to SCOTUS. So I guess I'd put it that way. Hello, Nunya. Good to see you. Good evening. Hello, hello. Very good to see you. Nope, I'm just getting started, Laura. I'm just getting started. No problem. Let's see the nails. Yeah, so these are my these are my Friday night party nails. Oh my gosh, I hadn't planned to back on live, but saw it and thought, well, let's just go through it. So we'll go ahead and get started then here, everybody. Yes, happy Friday. Absolutely. We made it. We made it through another week. Yay, happy Friday. Hello. Mish Gish. Good to see you. Mo Girly Girl, good to see you too. James, welcome. J Jack, welcome. Oh, I'm so glad to see everybody. So let me go ahead and just hop in. What we have here, typically what you want to do when you're requesting a case go to the U.S. Supreme Court. I'm sorry, I need to use two fingers. Here, it's fickle. She's moody. She's real moody. So you usually file what we call a writ of certiorari, where you're asking the Supreme Court to hear the case, right? And in this particular situation, what they're doing is they're asking the Supreme Court application to vacate the orders issued by the United States District Courts for the District of Columbia and request for an immediate administrative stay. So administrative stay would mean that everything would stop. The restraining order would be removed. Everything would make it so Trump could remove people from the United States using the Aliens Enemies Act is what they're asking for with this administrative stay here. They were denied this by the district court and by the appellate court so far. So this is their third court they're asking it of. And they're saying, we want everything to be paused here. And they're asking them, basically, this is what we would typically call an interlocutory type appeal, where you're right in the middle of the case. This case hasn't been decided. Our appeals are for when we have final judgments. All right, so final rulings. When you get your ruling in, thumbs up, thumbs down, then you appeal it, right? Well, we're right in the middle of this case. Right now, the only thing that's going on is a restraining order, meaning that they cannot use that Alien Enemies Act to move people. Because of that, we're right in the middle of litigation. And so we call this an interlocutory appeal, where they've already had rulings from two courts below the Supreme Court saying the restraining order is appropriate. And so now we've got a situation where they're asking the Supreme Court in the middle of their case to, reverse the temporary restraining order. So that's the application to vacate. Now, it's going to be interesting if they choose to do this for every single restraining order, because we're at about, I would say we're at, what was my last count? 130, 135 cases. Is that right? 137, I think. We'll just say we're around 150 cases, all right? We're rounding up a little bit, but in a couple more days, we'll see a few more cases. Cases are being filed every day, everyone. So let's just say we're around 150 cases right now filed against the Trump administration. And if each one of those, every single restraining order is appealed all the way up to the U.S. Supreme Court, oh my goodness gracious. We've had the other cases have been these restraining orders that are being appealed. So yeah, oh my gosh, oh my gosh, it's just a lot. It's a lot. And it's hard to watch. Hello, Achilles. Good to see you. It's hard to watch such just like a bad faith filings from these attorneys trying to drag things out or move things in the way that they're doing. It's hard to watch. It's hard to watch this kind of abuse, I guess, is the word I would use here. So yes, but that's where we're at. So that's where we're at for tonight. And I wanted to kind of spin us through what's been filed here and show you what they have put into the court today. Now, Supreme Court doesn't have to hear this case. This would be something on the shadow docket if we were going to go down that road. The Supreme Court doesn't have to hear it. They can say, we don't want to. I agree. All violations of due process are hard to watch. Yeah, I agree. I agree. Uh, but in particular, the way that they're doing all of these cases, I mean, I just finished adding 2 new categories to the closet docket, which I'll be going through at a later time. It's a lot, everybody. The habeas corpus cases right now are the ones that are driving me the craziest. The ones where we have a student out of Colombia, we have, I think, a total of 3 different activists who have been pulled in, no charges, pulled in, held, and they are, you know, they have the proper paperwork. They're not undocumented. They've got legal paperwork. So it's really frustrating. Printing out the documents and following along. Oh, of course, of course. This is a good one to learn a lot of legal concepts out of because there's a lot to it. All right, everyone, let's jump in. Now we've got Mr. Trump listed here because he's the one, the president of the United States, whatever, versus JGG et al. And we do know that their names have been put into initials to kind of protect their, so that they're safe. This was filed here by the acting solicitor general. Yikes. And here's our table of contents. So this is the format that we always use, of course, when we're filing at this level. We have the argument set out, and what we're going to look at here, the government is likely to succeed on the merits. That's very important. That's what makes it whether or not the restraining order should go forward or whether this should even be granted or not. Is this kind of a question? So number one, judicial review under the Alien Enemies Act is limited to habeas petitions in the place of confinement, meaning wherever you're located is where you need to file your habeas petition. Now, here's a little background. And again, here, everyone, I'm not reading verbatim. I'm walking you through the legal concepts here is what I'm trying to do. So habeas corpus means that you feel you are being unlawfully detained by the government. So habeas is saying, I need a court to acknowledge that I'm in custody and I need to be heard. That's what a habeas corpus petition is, all right? So what they're saying here is that wherever you are located, where you're claiming that you are illegally being detained, that's where you file your habeas petition. Because you could be all over the United States in any of the federal circuits and file a habeas. But what they've done here is they filed it in DC in particular because that's kind of where the home is of the Alien Enemies Act, as well as all of the other things going on. And they were like, well, you should have filed it in Texas. So that's what they're saying here. And they argued that out before as well. We all kind of heard those arguments in their appeal. 2, at a minimum, the district court should not grant nationwide relief. That was one of the arguments they were making early on, where they're also making that same exact argument in the birthright citizenship cases where they're claiming out in Washington, we've got a judge out there that put a nationwide injunction on the birthright citizenship executive order thing. And then we had another one in Maryland that did the same thing. They're like, look, nationwide. And so the Trump people are trying to say one judge can't put an order, an injunction out over the entire United States, only their jurisdiction, which is not true because they kept trying to do that against Biden. They kept trying to go in and say, we want to make sure that this one court's order covers all of the United States. And the court was like, sure, it does. So they're just arguing about it. And this is kind of, like this is yesterday's news over here. But we're going to see. They're still trying when we have no. Oh, I know. Oh, I know. It's just frustrating. All right, so that's number two. Number three, the courts below did not address the proclamation's lawfulness on the merits. Now, number three bothers me because, in my opinion, number three is a bad faith argument because when you're talking about a temporary restraining order, you're talking about kind of this four-part test that's set out. I think it's only four parts. It could be four or six parts, depending on how they break the language apart. But there's a six-part test, 4 to 6 part test. And if you meet enough of the pieces of the test, then you can have your temporary restraining order, which is temporary. We're talking like a couple of weeks at a time until everything gets into court and then they figure it out. So it's just temporary. It's just temporary. So when you go through that process, there each of those pieces have to be addressed, and those pieces do not include addressing the merits of the lawsuit itself. That is not one of the pieces in the test. And so this drives me bonkers because I'm like, look, that's not part of the restraining order review. What are you even doing here? And again, I think they're just throwing everything up against the wall. So it's like, okay, well, whatever. You don't get to just throw stuff against the wall and give it to the US Supreme Court. I mean, that's not going to turn out too well. Convinced they didn't look at it. Really? Oh, yeah, I wouldn't be surprised. And then number four, the orders are immediately appealable. And, you know, jurisdiction's been pulled in as a question. So that's just, I think, the kind of potpourri or everything else, miscellaneous, number four, for anything else we might not have caught here. All right, and then B, other factors support relief for the district court's order, apparently. And then C, this court should grant an administrative stay, which is, page 40, along with the conclusion. So this is, again, the table of contents here. Now, I'm not going to read through the whole document. We're here so we can kind of spin the wheel and just look and see what they filed here. I'm finding with a lot of these filings that it's just not worth it, everyone, to spend a lot of time on the language because the language is bad. I mean, we're not really learning here. We're not really seeing appropriate filings. So this is why they had that. Sorry. Well, oh my gosh, I know. Oh my gosh, VC. I tell you what, I fell out of my chair when I read that. Fell out of my chair. All right, first piece here, we have parties to the proceeding. So they've set out all of these people, and then we have our five plaintiffs here, all by initials. Next, we go into the proceedings that have already happened. I've walked you through this already. We would call this procedural history. So for those of you writing briefs, legal briefs, and studying law, we call this the procedural history there. And if you're with my color coding system, that would be pink and orange. Next up, we've got the actual application itself here. So we're going to dive into that. They're pulling out Rule 23 of the rules of this court. So rules of the U.S. Supreme Court. Every single court has their own set of rules of how they want you to behave. So it's basically, different houses invite you in, have different rules, right? So some people are like, take your shoes off. Some people are like, put your keys in a fishbowl, whatever it is. Everybody's home that you come into is going to have a different set of rules. It's the same with courts. They have a different set of rules on how they want things filed, on how they want things addressed, what kind of formats they want to use, and so on. So what they're talking about are the specific U.S. Supreme Court rules regarding writs here. Oh, thank you, Karen. I appreciate that. Doesn't seem like they always have legal arguments as much as they... Oh, true. I think that's a great way of putting it. To get... Oh, yeah, that's a good point. Yeah, it's a good point. So anyway, they're saying we are following the rules here, and we're filing an application to vacate the orders issued by the lower courts. And again, this is with regards to the restraining order. They're wanting them to put the restraining order back in place so they can move people out using this Alien Enemies Act, which we all are like, dude, there's no war going on right now. So, oh, my goodness gracious. They do a little history on that, which, okay. at least it's more than one paragraph to the U.S. Supreme Court, so that's something, I suppose. So we'll just fast forward here. Again, I'm just going to kind of scroll us through this so we can see. what's going on. So we've got a statement here. So I don't know. Sometimes we have a statement of facts. I guess we just have a statement here. I guess, like, all right, where they're just talking about the history of this organization. Again, they get so far into the weeds of this, and I mean, I guess it's fine. It's better than nothing, but this isn't the issue. The problem here is the factors in the restraining order that have been met, where both courts have decided they've been met. So we're going into more history here of the gang, blah, 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 blah. Somebody once said, blah, blah is that legal terminology? I'm like, it really is, because we do that a lot. ACLU said they are also representing the rest of the deported. Exactly right. Will those names get added to the same case once known? Good question. When we have a class of people, they're usually identified as just a class as opposed to individual names. So the name of the class would be included, and then if you like looked up the class, then the names would be included on there. But you don't even have to have all of the names in order for the class to be covered, and you won't. And that's one of the reasons why you need a class to cover everything, is because you just don't know who everybody is. You've not. Yeah, I agree. I agree. All right. All right. So next, we're moving on. Moving on. Wait, where's the A? I'm already like, this is their statement. All right, so Saturday, March 15th, 5 Venezuelan nationals, allegedly nationals, detained at an immigration detention center in Texas, sued the U.S. To block the government from removing them under the proclamation before the proclamation was even published. So I love this. This is one of my favorite things that the judge brought up. Both courts. The judge said these 5 people, the only reason they were able to file is because they knew about this proclamation before it was published. So these 5 people essentially were able to uh, stay in the United States. They were able to file this and have any due process at all because they had inside information. So everyone else who did not have this information, no due process. Some are in El Salvador. So that's kind of an issue. That's it's pretty awful. So just even the acknowledgement here that the only reason why we have complaints is because they had inside information. I mean, that's not looking good here. All right, here we go. So, respondents are asserting they're not members, they're wrongly designated. Only 3 of the 5 respondents initially pressed that argument, like, who cares? Nonetheless, they moved to certify a class, right? And then they filed a writ of habeas corpus. Now, what happened during that whole situation was a timing issue with the language in the law, where if you had a class and the restraining order, there was kind of a problem. So they pulled out the habeas corpus uh, filing because they could file it later on. They pulled it out in order for them to go forward. All right. Hours after they filed their complaint, without waiting to hear from the government, because the government's going to give them information, I think not. The district court granted their motion, right, ordered applicants not to remove any of the individual plaintiffs from the United States for 14 days. The government moved to stay the order and filed an appeal. I just have no sympathy for these guys that are not wanting any kind of due process. Later that day, without waiting for a brief from the government, again, they're all snarky about it, when the judge, a federal judge, a federal appellate judge, is asking for information, and they're like, we're not going to give you any. So, like, they're going to be waiting around for the government's information. Like, what? That doesn't make any sense. All right, fast forwarding here. Turning to the merits, the district court did not question the designation as this kind of an organization or the national security harms, because it's not necessary, including the gang conducting this kind of stuff. All right, this right here, it drives me crazy. This is where you see the nut jobs, the nutsos working for the Trump, that are like, we're so special and important. we're protecting something sacred. So, we can do whatever we want. Like the ends justify the means. That's what they say right here. This crap. Attorneys, trained attorneys, trial attorneys who are regularly writing legal documents up would not use this kind of crap, because they're saying here, let's talk about the merits of the case. That court didn't address these particular things. Again, not at issue. The only thing in a TRO hearing is the 4 to 6 factors on whether or not a TRO is appropriate. So deciding a case on the merits, we haven't even started that process. So this is very frustrating. So the way that this is set out, the language is set out here, again, is clearly, it's incredibly biased. And it's obvious that it's, his little, nutter butters in there making this argument. The court nonetheless held that respondents are likely to succeed in their argument that the act does not provide a basis for the president's proclamation. Under the court's view that the terms invasion and predatory incursion really relate to hostile acts perpetrated by enemy nations and commiserate to war. The court found the balance of the equities favors respondents. So that's a piece of this temporary restraining order test. And one of the things that they're not really factoring in, that the government's not really factoring in my opinion, is how incredibly knowledgeable this judge is. You're not just dealing with, like, down in Florida, the judge that had his case, she had like no experience. She hadn't done any cases really. I mean, she had a couple years experience. This judge has been here forever, and he like works on the specialty courts. So he knows all of this stuff. He works with the TORIS. That's it. So, I mean, he knows all of this stuff. So for him to come in and say, I agree that they're likely to succeed, is because he's got years of training and knowledge in this specific area. So that also frustrates me. All right, so we're scrolling because they're basically saying he didn't decide things on the merit. It's not likely that they would win. Court, of course, wouldn't address a claim. They'd not provide. Well, and that's the other thing too, VC. Such a good point. Like, the court can't decide anything if they don't have any information. And the judge has said that repeatedly. Like, you're not giving me any information. How am I supposed to decide this? And they're saying, well, you don't get any information because this is under Article 2, under the job of the president. And the judge is like, well, that's not how that works. And so here we are. All right, here we go. Scrolling here. All right. And then they're going through again and just complaining, which is what you do in motions when you're filing. They aren't inherently intentionally misinforming the courts. I don't know. I mean, who do you mean by, you mean the government? I would say they are. I would say that many of the things that they're saying are intentionally misinforming the courts. Absolutely. From their past filings. And then they base their current arguments on that information. And so it just keeps going every single time they file something. So this is down here. Here we go. Judge Henderson voted to deny the stay. Judge Henderson's like brand new, green-eared. Judge Henderson was the one that was asking the questions and talking about the Nazis. I apologize, everybody. I mix up the names a little bit here. But she determined the government had not shown a likelihood of success on the merits. And again, the judges do this based off of their training, education, and the amount of cases that they've handled and so on. Okay. So again, we're scrolling through 224 pages, everybody. So we're just kind of scrolling through here. Am I moving too fast, everyone? Hey, chat, am I moving too fast, or is everyone kind of following me? I'm just kind of pulling out learning moments from this filing is what I'm kind of trying to do. We are now in the argument section, but I'll pause here and wait and see. Someone's under duress and unintentionally misinforming a court. They cannot be held liable for that. That's not true. That's not true. If you're misinforming the court, it doesn't matter why, you can still be held liable. if you misinform a court, it doesn't matter what your intent is, you can still be held liable. It just has to be, there's different liabilities. There's different ways you're held liable for that. So, okay. Okay, excellent. Thanks, Doughboy. Thanks, Boxer Mom. So the thing is, you can have, I'm not defending them if they didn't know it was information. No, and I didn't take that as defense. I'm just saying, if you intentionally inform misinformation to a court, you can be charged criminally for that. But if you are negligent or you are pressured and you don't even bring that pressure up and say, hey, I'm being forced to do this, and you don't make that known to the court, you can have all kinds of ethical violations still too. So that's what I'm trying to say here, is that there can be lots of different pieces to it. You don't have to have intent to be called out on it, I guess is what I'm trying to say. If you're doing it on purpose, you could be looking at worse charges. But if you're doing it negligently, right, you can still have some issues, right, versus intentionally. All right. Okay. Thanks, Heather. Appreciate that. So next we're into the argument area here. Under Rule 23 again, and then they just kind of bring that back up. Like I said, I've been in situations where I'm pointing out an attorney intentionally misinforming the courts about me. All right, sweetest nightmare, I'm gonna need you to hold on, all right? Because one thing that can get a little bit frustrating for me, and my moderators and my people here will tell you that, is when I have people come on here and start saying, well, in my case, the judges screwed me over. In my case, the court screwed me over. Or in my case, everybody was terrible. So that kind of stuff is like not really helpful. You know what I'm saying? So take a break. If in your case that's happened, great. But in this particular, all right, John, you need to block. Sorry, I'm gonna take a drink here. You need to block. I can't deal with it. She needs to go. All right. She needs to go. BC, who's blocking? Thank you. Appreciate it. VC, sorry about that. Tea break, everybody. All right. Ignorance of the law. Right. Oh, right. Thanks, Achilles. Actually, I will. I'll keep that. Oh, no, that's fine. It's okay to talk about it, but it's like, gosh, you just can't keep coming after me, man. These people come in here and do that. Oh, I know, but it's okay. And she's commented, I don't know if it's a she or not, forgive me. But she's, come in multiple times on other things and we can talk about it. But I think, we get to a point where it's like, you need to stop smacking at me. You know what I'm saying? All right, back in it. We're in it to win it, everybody. Oh, you're teaching him to play spades. Oh, I love that. I love that. That's wonderful. No problem. All of my moderators are amazing here. All right, everyone, let's dive back in. We're into the argument. Again, the government is likely to succeed on the merits, which is just one of those things that you argue in court. She wasn't coming across clearly. Yeah, and it's hard, the written form is hard to come across clearly, but then it's like you just drop it. Judicial review under the AEA is limited to habeas petitions in the place of confinement. Again, we've talked about that before. That was one issue. Hello, medic. Good to see you. That was one issue that they brought up, that third judge that did not agree in the Court of Appeals was talking about. He kind of hit on this idea that it should have been raised in Texas as opposed to where it was. So that was kind of his big shtick. And so, of course, they're going to come back. This, by the way, Ludecki or Ludek v. Watkins, this is the big case right here that they're going to be citing over and over and over again. This is where we had the alien enemies situation occurring before, so previously, 1948. So if you're wondering what case to look in on, I might do a post on that, on the Ludecki case. Hold on, everybody. I got to make a note. Note to self, do the Ludecki case here. Ludecki. My whole system's different here, so you're probably hearing like every crinkle of the paper. Oh my gosh. Okay, good. See, I know. Great minds think alike, of course. Ludicky. Yeah, they've been talking about that quite a bit. So, okay. Next, they're going in here. Government agrees the cause of action. Again, habeas corpus would be available. Now, one of the things, and another little side note, everyone, that I was thinking about when I was listening to the arguments in the Court of Appeals, they were saying no due process is needed because of the president's executive authority. All right, that's one of their arguments. Like the president can do whatever they want. But then they're saying, but habeas corpus is available anyway, and that's the due process that would cover you. So they're using both roads. The one road of saying the president doesn't have to give you due process and habeas is available. And they're using that to argue, that there was due process, which I find fascinating here. All right, why does the government win on the merits? Because that's, this is their pleading. So they're going to say we're winning on the merits. They're going to try to find everything where the government wins. Okay, dokie. We're skipping through again here. All right, page 20. Yeah, it's 224 pages, everybody. That's why I'm like, scroll, scroll, scroll. Moving on. And again, you can take some time to go through these cases if you're interested in that and look through these arguments. I will probably take some time to actually go through some of the meat of this, but a lot of it's just not helpful. A post on that would be great. Yeah, I think I want to do, there's about three or four cases that are in here. And what I might do is a longer format where I just do all the cases just in one post. All right, at a minimum, district court could not grant nationwide relief. And we've talked about this one again, where the Supreme Court has said that that's just not true. So we'll just go forward again. We've got that. Look at this. Thomas concurring. All right. You're going to see that quite a bit. They really pull in Thomas quite a bit. I'm scrolling through to the next piece. I think the other thing too, everybody, is I'm in my kitchen. So the air conditioner and the fan's off so that it doesn't make any noise. And I just made this huge casserole and I feel like I'm on the inside of my oven right now. So, oh my goodness, it's so hot. All right, the course below did not address the proclamation's lawfulness on the merits. We've already kind of talked about that. Yeah, you're right. Oh my goodness gracious, Thomas. Somebody said Alito made a statement today. I haven't seen it yet. Oh, turn them on. No, it's all right. It's all right. This is good. I'm like working on the facial here. What time's dinner? Oh, turn the AC back up. I'm okay for now. Listen to me. I'm just complaining. I'm just I'm looking at a situation where people were taken to El Salvador and I'm like, oh, my stove was hot. It doesn't seem right. All right, here we go. And now this piece, I think we should spend just a little bit of time on here. Oh, I'm good. I'm good. I have my bingo cards here and I'm using it as a fan. So I'm doing fine. Oh, let's take a couple minutes though and talk about this. This is kind of a newer piece that we haven't really seen in any of the pleadings or arguments before. So they're saying the orders are immediately appealable. Here, they're talking about that DC circuit, right? So they recognize the district court's orders were appealable despite being labeled as TROs, not preliminary injunctions. The label attached to an order is not dispositive. Instead, where an order has the practical effect of granting or denying an injunction, it should be treated as such for purposes of appellate jurisdiction. The reason why this whole argument comes in here, I know my bingo card's going to need to be updated, but the reason why they're even bringing this in is because there is this question about whether or not a TRO, a restraining order, is enough of a definitive decision by a court to be able to appeal it. It's an ongoing legal argument. It's an academic argument. And so, it kind of goes around and around and round, that it's not a final decision because it's so temporary. It's only a couple of weeks. And so by the time you appeal it and you get a decision from the appellate court, the temporary restraining order is probably done by then. So there is really this big question about that. And so that's what they're arguing here. Is they're saying that as soon as that order was put into place, so 7 o'clock that night, I guess, is what I'm thinking they're arguing here, is that they are saying we should have been able to appeal it in that moment. Watching you making dinner. Yay! That's important. Oh, true, true. I know, I know. I just am like, this case is so it's very it's dark, everybody. We're in a dark place with this case, but all right, let's keep walking through it. So that was the big argument in that for that particular factor, everyone. I think it's important to remember that. All right. Next, we've got other factors supporting relief from the district court's orders. And again, keep in mind that they do not like this district court judge here. Ooh, all right, here we go. I'm going to read this part because they kind of go after the judge a little bit. The questions raised by this case plainly warrant this court's review, meaning the Supreme Court, where we've got Justice Barrett saying that. And this is the Doe's case. And this is self-evidently no ordinary case. The DC Circuit took the unusual step of holding expedited argument 9 days after receiving the government's stay application. Again, there's some exigency with this case. Then issued 93 pages of opinions 2 days later. I mean, right? What's wrong with that, man? We needed the information. This case raises paramount questions about the president's constitutional and statutory authority to protect the nation against elements of a designated organization that the president has determined has been conducting irregular things here, as well as the extent of judicial review of decisions to remove those individuals. This right here, this is the power play. This is where we have these questions between Article 2 and Article 3, where they're saying we shouldn't have any kind of reviewability over these Article 2 powers. Meanwhile, the courts and the Supreme Court is like, that's not true. Everything gets reviewed. Right here, they're citing the Trump v. Hawaii case, which, as a friendly reminder, is the Muslim ban case. So they're saying, again, it's not reviewable because it's within the core duties of the president. Right. It's not. I mean, there is no war. They're just saying, well, who cares? The president wants to use that act, and he's going to declare that this is, basically fitting into the categories of that act. And so there you have it. Like, the president doesn't get to make those decisions. And that's the problem here. They're saying he does, and he doesn't. It's the courts that make those decisions. So, the friction, and then we have the friction. And there's a lot of friction. All right, so fast forwarding again here. Again, and they're just kind of recapping what the appellate court judges wrote in their decision here. I don't want to walk through it. I know it. I know. I want somebody to helicopter me out of here with this crazy town business here. All right. Next, vacating the restraining orders would not cause irreparable harm to respondents. So just think about that sentence right there. So they're saying here, if the TRO was vacated, which would mean that they could pull anybody that they think is part of that gang in Venezuela. They could pull them off the street. We don't need any charges. We don't need any criminal activity. Just they think so. Pull them off the street and then do whatever they want with them by kicking them out of the country and sending them wherever they want under the Alien Enemies Act. They're saying they want that back in place because it wouldn't cause any harm to the respondents. I mean, that's crazy talk. That's crazy. Judge Millett in the district court paint the government as wrongly denying respondents any process via summary removals, but expedited removals happen under Title VIII within hours of border crossing. And that may be true, but they don't happen when you are claiming basically war, right? A country is warring with the US. That's right. So, I mean, that's a different category here. I don't think they get that. Yeah, we've got public health expulsions here, and then aliens are often not entitled to drawn out procedures to attack immediate removals. True, but they do have basic due process, right? Or at least a determination as to whether or not they're actually the people included in the order that's allowing them to kick them out of the country. You know what I'm saying? Autism awareness tattoo. I don't doubt it. I don't doubt it. Right, you still can't see the nails. Ah, my light's fading. There we go. Look at that. That's what all the old school people used to do, right? There we go. And then this batch. These are my party nails. It's all just a distraction. In the meantime, they're swiping people off the street. Well, exactly. Exactly. But they're getting caught. Again, I have to say, we've got a handful of cases where people are literally being pulled off the street that are legal residents and are filing habeas cases. I mean, it's just yikes. It's a lot. All right. So again, here, that's a pretty weak argument. Regardless, the government agrees respondents are permitted judicial review, but only through habeas. And again, this argument falls flat because the other times the AEA has been used, due process was not just habeas. Due process had hearings involved, for the schmatzis and for the internment camps as well. That's how Korematsu was able to take his case all the way up to the U.S. Supreme Court. There was a process for it. Allison, that's exactly right. That's exactly right. All right, so here we go. Here we go. Moving forward. I want to see what else they've got here. All right, so finally expressed concerns that the moment the district court TROs are lifted, the government would immediately resume removal flights before respondents have an opportunity to file for a writ of habeas corpus. And I think that that is absolutely true. But respondents have already had almost 2 weeks in which to file habeas petitions in Texas. Again, remembering that they filed habeas and then pulled it back because of what was going on and will file whenever they want again. Having opted against the path the law provides, respondents cannot demand that their removal be enjoined. This was the arguments from the plaintiffs, where they said to the judge in DC, we'll file a habeas right now. Here's your notice. Here's your notice of habeas right now. And the judge is like, you don't have to do that based off of, what the government's saying. You don't have to do that. So, I mean, it's pretty clear that, habeas is absolutely on the table, but it's not required. And the government's arguing that it is required. So, we don't know. We don't even know, John. I mean, this is just dark days. All right, next, the court should grant an administrative stay, which is actually what they should have pled to the Court of Appeals. For those of you that listen to those arguments, the Court of Appeals, one of the judges said, well, shouldn't you have already filed this? And they said, yeah, but you didn't, right? And they said, no. So here they're asking for that stay again. And then we have their conclusion. We're on page 44, everybody, of 224, all right? And then here's our conclusion paragraph. Here, oh my gosh, by our acting Solicitor General. I just feel bad for these attorneys that have to leave these jobs because, it's such an ugly situation. Vacate the district court's order. In addition, the acting Solicitor General respectfully requests an immediate administrative stay, right, pending the court's consideration of this application. So our Solicitor Generals get involved anytime the U.S. Supreme Court's involved. So that's the conclusion. So now we have the appendix. Now we have all of this extraneous stuff that they have added on. Let's take a look here. El Salvador. Right. I mean, yeah, all you have to say is El Salvador in prison and nothing good's going to come from that. Quite frankly, I'm just not, and quite frankly, any country. I mean, any country other than, I don't know, maybe, well, even Denmark, I think, has got some problems. I've yet to hear of a country where the prison's like, well, it's no big deal, whatever. 3 squares a day, and it's great. That's not going to happen. And the more impoverished the country is, the less ability that they have to provide for basic necessities with prisons. I mean, quite frankly, the US, our own prisons are a nightmare. So, I mean, they're not going to win on like some guy last night. Gosh, I was on Amanda's Live, everybody, on the TikTok. And that DJ guy, oh, he gets me every time. I'm just like, oh my gosh, why are you still talking? But he was saying, oh, El Salvador, they're doing great things for their people. I'm like, that's just not true. It's just not. That's just that. No, I'm not going to do that. It's like talking about, well, Uruguay is doing a great job. Like, are you kidding me? Alabama, exactly. Louisiana, exactly. Quite frankly, even, I mean, Texas has some pretty awful human rights violations going on there. It's a lot. It's a lot. All right, so let's see what they've included here, everyone. So these are the additions to the actual filing here. One hard-boiled egg in the morning and 2 meals of beans and rice, and that's it. Well, honestly, the least of my concerns would be the food. I'm gonna give it to you straight, everybody, as a quick side note, and then I'll dive back into the documents. One of the biggest, one of the biggest things you can do to harm a human, right? So I'm talking about, if you're captured by opposing countries, is to deprive people of sleep, right? That's a technique that's used on our military to train them in basic training and get them used to what that kind of, torture's like. But that's one of the biggest things you can do. And I know it's like, oh, you can't go to sleep. What's that? But if you truly, if you go for a very long period of time without any sleep or without appropriate amounts of sleep, you will go crazy. It absolutely is a torture technique. And I cannot imagine anyone in the prisons there getting very much sleep, right? So at this point, food, yeah, they don't want you to starve to death, but with the conditions there, I mean, there's no way you can sleep. So it's just 24 hours of a nightmare, just over and over and over again. All right. I'm off my soapbox, everyone. Back in. Next up, we've got the U.S. Court of Appeals here. So they're including that. That's the March 26 filing here. The order from our judge here. This is the circuit judge, right? So this was the argument that we listened to earlier. Oh yeah, 24/7. I mean, anybody that's been in a medical facility, part of the problem is that you can't ever sleep because basically every 45 minutes you're woken up again, which technically is a torture technique. I'm just putting that out there, right? Anyone who's had a baby, oh my gosh, yes. Those first 3 months, everybody, oh my goodness gracious, yes. Exactly. So here we go. We've got the circuit judge's decision here that he has added. And we've got 93 pages. All right, well, that explains half of the 224 pages. Typically what you do, I'm not sure about including entire opinions. This was something Mr. Trump's attorneys did on his other cases too. And I've seen attorneys do this, but I don't know if you need to include the entire decision because the whole record's going up anyway to the Supreme Court. So it's not like they don't have access to the record. But anyway, I'm just complaining. I'll move forward here. So this is the appellate court's decision. I've not done a live on that because TikTok's crazy right now. We're in crazy land over there. Oh, all right. So that's one of the, again, this is all, I'm reading the page numbers up here, everyone. That's how we know how we're spinning the wheel here. Page 93 is what we're looking for. We're on page 81. Spin the wheel. And 93. All right. I respectfully dissent here. Oh no, did we get another troll? Oh dear. Oh yes. Get so much. Oh my gosh, I know. You can't, I mean, you can't rest in there, right? But I mean, what else can you do? They come in to make sure you're still breathing, so I suppose that's okay. They're like, you need this or else bad things will happen. Fine, I guess. I guess if you have to, in order for me to survive the next 3 hours, fine. All right, I laugh so I don't cry. Here we go. Here's the next addition that was added. We've got the memorandum opinion from the judge, in the, and this was a great decision. I've read through it. I should probably, I'm thinking about doing highlights. It's 37 pages that they've included here. I'm thinking about just pulling the highlights out of this particular ruling because I thought it was pretty good. Is TikTok still going away? I think so, but I feel like the self-destruct button has already been hit. So even if there's some kind of, life preserver sent out, that's not the right thing, right? Life preserver, that's not right. You know what I'm saying, right? If somebody sends a dinghy out to the Titanic, it's still going down. That's a terrible reference. It's self-exploding is what I'm trying to say. Yeah, there's been a lot of problems. A lot of creators are getting huge strikes, having their accounts taken down, just not wanting to do it anymore. So, yeah, we're moving over here. The Exodus is happening right now. Moses has spoken. we're, we're leaving. All right, everybody, we're getting out of here. Oh my goodness. All right, here we go. Titanic, we're like in the Red Sea. What's happening here? All right, it's the heat. I'm goofy. Here we go. Let's fast forward. I'm just trying to show you the documents they've included here, everyone, before I lose all of my credibility. All right, Judge Boasberg. His decision here. And then we've got the order. And so they included the motion to vacate being denied, and that was denied by Judge Boasberg here. We also had, I think it was today. Was it today or was it yesterday where we had a judge come out and say that on one of the cases they were asking for her to remove herself, and she's like, "You are questioning my integrity," and she was mad. I can't remember which case it was because I've read too many cases today, but yikes. All right, here's our civil docket again. So what they've included, it looks like they've included the Court of Appeals decision, the lower court's decision, and the denials of different motions here, along with, so now this is what I'm wondering about. What is this here that they included? So we'll look in here. And then they put together, it looks like, yeah, I just can't remember what case it was that they were asking her to be removed off of. I just cannot remember. I think it was a law firm. Was it one of the law firm cases, maybe? Well, anyway, so they put together some kind of an Excel chart here of the docket. So, when we go through the docket and I walk you through it from Court Listener, this is what they've done. They've just created their own docket here. So we've got transcripts in here. So they've put their own docket together to give to the Supreme Court. It's kind of a weird filing they've got going on here. We have our declarations in here that had been filed. We've already read through those. A law firm caved today. Another one? I don't know. I know there are two law firms and they're both fighting. I didn't know one had caved today. There were three law firms. One caved. Are you saying a second one has now caved? Oh dear. Oh dear. And here we go. Declaration of an acting field officer. So this guy, everybody, this Robert Cerna fella is the one that's kind of, it sure did. Oh man, I'll have to get in on that. This guy is the one who is like that, the bureaucrat in Texas who is saying, well, I just basically decide. I basically decide what happens here with that. All right, and then we've got transcripts. This transcript here, whoopsie doos. Here we go. Whoopsie daisies. Oh dear. Oh dear. What happened? That's not what we were looking at. My goodness. All right, everybody, hold on. We've taken a bad turn. Hold on. We got to remember what page you're on. I don't have any other tabs open that would be weird. Like, good thing I put my brownie recipe away. Goodness gracious. Oh, goodness. All right, where did the train? Okay, let's look here. All right, we're looking after the docket here. All right after this. They're just really every good person. Oh, I know. That's very interesting. Concern of the swamp creature. Well, yeah, right? I mean, gotta drain the swamp, and he's like the swamp man. All right, fast forwarding. I want to see what this transcript was here, everybody. I'm dragging you with me. This is really just for me, for my own personal knowledge on what's going on in this case. There we go. We have, okay, this is the March 15th motion hearing. This is interesting, actually, to have these full transcripts. It looks like we've got several pages of these transcripts. Oh, maybe I should do a live reading through them. Let's see, what do we have? We've got about 10, 12 pages. What about the casserole recipe? Oh my gosh. We want the brownie recipe. My goodness. Oh my goodness. That's funny. All right. Right. The judge lifted the temporary stay. Yeah, I saw that. There were a couple of things that probably went down today. I've not seen them updated on the dockets, but yeah, we've had a couple of stays that have been put into place where we've had TROs reversed, and that's kind of the nature of the game here. Ooh, banana muffins, yum! Special brownie recipe. Yeah, you probably are all thinking about a different kind of special brownie recipe. I'm just getting that now. All right. I have a recipe that uses no flour, and it's a black bean brownie recipe. Meanwhile, you all are thinking of a different kind of brownie, I think. Oh my goodness. Everyone. I'm so focused on like what this transcript says. I'm like, who wants a brownie recipe right now? And I'm getting it. Oh my goodness. Oh my goodness gracious, everyone. We're all going crazy. Oh my gosh. Oh dear. All right. Sorry about that, everybody. There's another brownie recipe that I have that's like a brownie mix and a can of pumpkin. And you mix it together and you get like these amazing brownies. All right. Anything to get us through. That's not legal in my state, so you don't have that. All right. So another thing here, we've got some transcripts from the 15th. Oh my gosh. Oh my goodness gracious, everybody. Fun on a Friday night, right? Am I right? Almost as fun as trying to figure out Star Wars terminology, but not quite. Yeah, they taste pretty good. But I mean, it's black beans. So it's also got all of the elements of black beans. So it's very healthy. Here we go. And then they've included the actual proclamation here. Note it's a proclamation, not an executive order, and of him invoking this Alien Enemies Act. I really couldn't tell you how, well, I mean, for Thomas will do whatever Trump wants him to do. Alito, he'll just do whatever hurts the most people. But for everybody else on the court, I really have no idea how they feel about this whole situation with the Alien Enemies Act here. Earthy. Yeah, I mean it's really light flavor. If you use extra good chocolate, it's fine. It's legal. Kathy, I'm coming over. Just don't eat too many. Yeah, exact. Moderation's your friend with your healthy brownies. Oh my goodness gracious, everybody. We're all losing our mind. And this is the last page. This is page 224. Oh my goodness. That's what I'm saying, VC. Exactly. That's what I'm saying. So this is the last page. So we've got 224 pages. So we've got about 30 pages of his request. And then we've got the district district court's order, the appellate court's order, the denials of vacating, and then some transcripts from the original hearing on the 15th, right? It's the 15th, wasn't it? And then he included the executive order. Our minds have been long gone. True story. True story. Bring your shovel. Oh, dear. Oh, my goodness. Can you imagine? No, no. And there certainly isn't any record of anything like that. Oh, my goodness gracious. Oh, that's funny. All right. Judge Howell. Right. For recusing her. Right. Right. Oh, I love that, John. I love that. I mean, all the judges have been getting some trouble. Now, I thought I read too that Grassley even piped up today, and he's, the head of the Judiciary Committee in the Senate, and said, I mean, I'm always fascinated. I'm fascinated by Grassley because he's 91 years old. And he came in and was like, don't pick on the judges or whatever. And I thought that was pretty good. Good for him. I mean, I don't know what's going to happen from that. Really, really. I'm in Minnesota. All right, I'm getting in the car. Expect me in a day or so. Oh my gosh. Oh, that's so funny. So so that happened too. But yeah, I want to look up Howell because I heard that she's not playing around, and I love that. I thought she actually was the Chief Justice in the DC District Court before the current judge. So, but I may be wrong. All right, everybody. He said you can't impeach a judge just because you don't like her opinion. Right, right, which is exactly what Robert said as well. Told them it's her job to adjudicate, not the president's. Yes, oh, that's exactly right. Ooh, I'm excited now. I'm excited to read her decision because I'm a dork and I'm okay with that. I'm comfortable with that level of dorkness. But that's good to know. Yeah, I had just heard that she had made that. So, ooh, excellent, excellent. All right, everybody. So we made it to page 224. So what, it was a roundabout. Yeah. I'm a bit on my loopies tonight, my legal loopies. So what do we have? We do need some SmackDown wins, and we're going to get them. I think they're coming, too. I think they're on the way. He surprised me as well. He surprised me that he said anything because he rarely ever says anything. But do we have any questions then? I love the level of dork. Now, I tell you what, everybody, for those of you that were on my live yesterday and we were talking about, that big machine creatures walking around with the big legs in the Star Wars, and I couldn't remember the name. And so everyone was putting in AT-ATs. And so I was saying AT-AT, and then someone, I'm not going to say who, John, said it was pronounced at. I said to my husband, I said, do you remember the AT-ATs in Star Wars with the Ewoks? And he's like, none of what you said is correct. He's like, you're on the wrong planet, first of all. And no, that's not. Oh my gosh. So yes, I had several people here in my home that just looked at me with pure disgust. Oh my gosh. And he was like, I am ashamed of you. I felt kind of bad about it. I mean, I didn't feel too bad about it, but oh my goodness gracious. You gotta have fun when you can, right? Right? I mean, come on. These are dark days. We gotta laugh when we can. Yeah, and I mean the executive orders keep coming, everybody. The executive orders keep coming, the lawsuits keep coming. I'm on my third poster board now, because I had to add so many more cases. I mean, it's just a lot. We have to stay in our own geek lane. That's so true. That's so true. Exactly. And that's okay. That's okay. Did you go over the appeals court giving the green light to Doge to have their... So I haven't gone over that yet, no. But it's more nuanced than that. I do plan to actually go through that. And we weren't surprised that that was coming based off of how the restraining order had been written. So I'll dive into that so I can explain it better to everybody, and I will do a post on it. Now, here's my question though, again, as I'm just trying to get used to YouTube here being my number one. I'm noticing that the shorts definitely are interesting to people. They're grabbing onto and watching those. But the longer formats, I'm not sure if that is actually getting out to everybody. So I'm just curious if any of you have seen the longer format videos, because if it's longer than 3 minutes, I have to put it in the longer format. And so my question is, which one do you like better? Do you like the shorts or do you like the longer posts? So we'll do a chat question here. And I'd do a poll if I knew how to do that, but I don't. So I'm not at that level yet. What do we think? What do we think? Shorter? Shorter or longer? You like both. Okay, you like a mix. Longer. Directly to your page and find them. Okay, okay. We will survive these 4 years. Absolutely, we will. Absolutely. I had to read you. Okay, okay. Right, both. I like the shorts. I like both. I like both. I like the long better, but I have to go to your page to get to them. Okay, that's what I was thinking, Jennifer. That's what I was thinking. They're just not getting out. They're not being circulated like the shorts. Yeah, I think the format of the shorts I think is okay sometimes. And I mean for quick updates, they're fantastic. But if I kind of want to get into more details, you need to go a bit longer. They show up more, but you like the long. Okay, so the mixed, it sounds like the mixed is the best. Crop the long into shorts and then link to the long. Oh my goodness gracious, genius. Hold on, let me write that down. That's genius, T sharp. All right, all right. So short and then link the long. Wow. Okay, all right. Link long. Okay. I'm gonna do that. Ah, my favorite's the lives. Yeah, well, we're gonna keep on doing those. I'm working on it. I've got some new setups going on in here. Great when time's short. Yeah. So what I was thinking, and the reason I ask is because, we're not quite, I think it's 137 cases that we're at right now. And I would like to go through and do a quick update on any of the movements for some of the cases. And those would just be real quick, like the restraining order's been lifted, injunction's been set as permanent, those kinds of things. And those are great for short. But then the longer ones, I think, to explain something, it takes more time. Even if you are only set notifications, they won't show on your phone. Really? Okay, that's good to know. Okay, okay. You can do parts too. Yeah, and I did that too below within TikTok. One thing I'm putting together right now is all of my playlists. So like my playlist for all of the E. Jean Carroll posts that I did and the lives, well, not the full lives, but the posts that I did, I'm putting them all into one. So it's gonna be like, it'll be like 90-minute posts. I mean, it's a huge post, but you just fast forward through everything. So I thought that would be fun. But other than that, I try to not do anything more than 10 minutes. Barely. Yeah. I mean, TikTok's going down. I mean, it's yelling timber. It's going down. Right, right. And we're all coming over here. We're all coming over here. Hello, H. Titus. We're coming over here. The more advanced people are on the Substack. I'm trying. I'm looking around out here in the sticks, and I'm like, does anybody know Substack? And they're like, what's that? It's an app. So I'm here. Yeah, exactly. Exactly right. We're definitely making the move for sure over here. I mean, when I say we, I mean kind of like our group here, our people, our attorneys that come in here and hang out. Do you still have access to your original lives on TikTok? No, unfortunately, no. I have they keep the lives for 30 days. So any of my lives from a year ago, any of my old lives are going to be on YouTube here. So some of those have been posted that I did. I know even I've got at least a year, maybe 18, well, more than that, even because my Halloween one I posted 2 years ago. So yeah, you can go do those all the way back, but not on there. So yeah, I'm trying, everybody. I tell you what, I mean, I, I'm working on it. I don't know how all this stuff works with this technology. I think somebody posted one of my favorite comments today on one of my posts. I was doing the closet docket and just showing all the post-it notes. And she wrote, "This is amazing." And I was like, "Oh, no, thanks." And she's like, "Can you put this in a spreadsheet somehow?" And I'm like, "Oh, man." It's like, I just felt so like, oh man, everybody does a spreadsheet, but nobody else does a closet, right? I thought that was so fun. Just like, well, we all have our thing. I know, right? Right? I'm too old. I might lose. Oh no, no, no. I'm definitely my primary new residence will be the YouTube here. So for sure, I'll be here. I think the closet's best. Well, and I need to do a post explaining where you can find them on Lawfare and the Free Law Project and just security. There's lots of places that have them in great formats like that, but yeah, I'm a post-it. I have to have my post-its going. So exactly, VC. That's what I'm saying. And I think what I'm going to start doing is putting those three websites. Those are the three primary websites that I use. And I'll probably just put a sticky note up on the closet docket and make sure that I show that so people know they can go to those websites. That's where you can find that. So we need more closet doors. No, it's too much. Oh my gosh, really? Oh, I love it. Oh, I love it. That's such a great, oh, good, good, good. We love to hear that, Achilles. We love it. Finding them in the weirdest places. Yes. Well, yes. Right. Oh, my goodness gracious. All right. Well, with that, my friends, I should probably go ahead and close us down for tonight. But this was an unplanned live. I appreciate all of you coming over here and hanging out with me. I, just saw that this had been filed, wanted to go through it. Although my ADHD was finding squirrels constantly, still we made it through, nevertheless. Oh my gosh, do Atticus and Pearl ever pull them down? No, but they chew. They chew on, I've got boards that I put on my table, like the blue background, the blue in the black backgrounds. And the sides of the boards all have like a little chewy marks on them, like claw marks. Oh my goodness gracious. Oh, I'm happy. I'm happy to be able to come and share this information. And everybody has such great questions and comments. So I'm thankful for you all to join me whenever you can. So with that, I will sign off for tonight because I've got to go party with my party nails. And so fare thee well for tonight. I'll be back again very soon. And again, this is going to be my permanent home. I'm probably going to put up a lot of posts on TikTok over the next 48 hours just because it's going down. So you may see that, but I'm going to try to not overload you over here. So take care. Thank you so much, everybody. All thanks, Upgrade 2.0. Oh, I appreciate that so much. Take care. I'll see you all again soon and hope you all have a great weekend.